The muzzle flash in a Texas parking lot in December 2019 was not just a discharge of a firearm, it was the opening salvo in a legal war that would eventually tear the United States Supreme Court apart and stitch it back together in a shape that few gun owners recognized. Picture the scene, a lunch meeting between a man named Zaki Rahimi and his girlfriend. It was supposed to be mundane, but the conversation curdled into violence. When she tried to leave, Rahimi didn't just shout, he grabbed her, threw her to the ground, and dragged her toward his car, shoving her inside with enough force to slam her head against the dashboard. As bystanders watched in horror, realizing a kidnapping was unfolding in broad daylight, Rahimi reached for his waistband. He didn't pull a knife or a fist. He pulled a pistol. He fired a shot into the air, a crack of thunder designed to freeze everyone in their tracks, before speeding off. That single trigger pull set in motion a chain of events that would bypass the local precinct, skip past the State House, and land squarely on the desk of Chief Justice John Roberts, forcing a confrontation between the harsh reality of modern violence and the parchment of the Second Amendment. Welcome back to Gun and Gavel, where we do not just read the headlines, we dissect the forensic evidence of the law and the ballistics of the courtroom. Today, we are conducting a deep dive autopsy on the most significant, confusing, and pivotal Supreme Court decision of 2024, United States versus Rahimi. Most of the mainstream media glanced at the 8-1 ruling, saw that a domestic abuser lost his gun rights, and moved on. They missed the story. They missed the fact that this ruling didn't just put one bad guy in jail. It fundamentally rewrote the operating system for every single Second Amendment challenge moving forward. It touched on red flag laws, nonviolent felons, and the very definition of what it means to be a law-abiding citizen. If you own a firearm in America, the rules of engagement just changed, and you need to understand the new ballistics of your rights. Before we break the seal on this legal dossier, make sure you are subscribed to the channel. We are tracking these cases with the scrutiny of a crime scene investigator, and you do not want to miss the evidence we are uncovering. To understand why Rahimi is such a seismic event, we have to profile the antagonist. Zaki Rahimi was not a poster child for responsible gun ownership. He was not a hunter, a collector, or a citizen caring for self-defense. He was a one-man crime wave. After the parking lot incident, a Texas court issued a civil protective order against him. The order was explicit. It suspended his handgun license and federally prohibited him from possessing firearms under 18 U.S.C. Paragraph 922 G.8. Rahimi signed the paper. He acknowledged the court's authority, and then he proceeded to treat that court order with the same respect he treated his victims. Over the next 2 months, Rahimi engaged in 5 separate shootings. He fired into a house. He fired at a driver during a road rage incident. He fired his weapon in a terrified frenzy at a Whataburger after his credit card was declined. When police finally executed a search warrant on his home, they didn't just find a man who had made a mistake. They found a pistol, a rifle, ammunition, and, sitting right there on the table next to the contraband, a copy of the protective order he was violating. This seemed like an open and shut case. Federal law is clear. If you are subject to a domestic violence protective order that finds you to be a credible threat, you cannot own a gun. But Rahimi's lawyers did something audacious. They didn't argue he was innocent. They didn't argue the shootings didn't happen. They argued that the law taking his guns away was unconstitutional. And here is where the story shifts from a standard criminal docket to a constitutional crisis. Just 2 years prior, in the landmark case NYSRPA versus Bruin, Justice Clarence Thomas wrote a majority opinion that threw out the old way of judging gun laws. No longer could judges balance public safety against gun rights. Under Bruin, the government had to prove that a modern gun law had a distinct historical analog from the founding era, specifically around 1791. If the founding fathers didn't have a law like it, the modern government couldn't enforce it. The Fifth Circuit Court of Appeals, looking at the Bruin test, made a ruling that shocked the nation. They looked at the history books of the 1700s and found nothing that explicitly banned wife-beaters from owning muskets. In the 18th century, domestic violence was rarely prosecuted as a felony. It was often considered a private family matter. Because there was no direct historical twin to the modern domestic violence ban, the Fifth Circuit vacated Rahimi's conviction. They essentially ruled that because the founders were silent on disarming abusers, the modern Congress was powerless to do so. In Texas, Louisiana, and Mississippi, the federal law protecting victims of domestic violence vanished overnight. It was a strict, robotic application of history that prioritized the silence of the past over the screams of the present. That is the grenade that was tossed into the lap of the Supreme Court. When the decision finally came down on June 21, 2024, the legal world held its breath. The result was an 8-1 reversal of the Fifth Circuit. Justice Roberts, writing for the majority, reinstated Rahimi's conviction and upheld the law. But the score doesn't tell the story, the reasoning does. Roberts had to thread a needle through the eye of a hurricane. He had to save the domestic violence law without overturning the pro-gun victory of Bruin. His solution was a subtle but profound shift in how we interpret history. Roberts wrote that the Second Amendment is not a law trapped in amber. This was a direct shot across the bow of the lower courts. He argued that Bruin did not require the government to find a historical twin to the modern law. It only required a historical analog. He was telling judges to stop looking for a Xerox copy and start looking for a rhyme. Roberts dug into the archives and pulled out surety laws and going armed statutes from the founding era. Surety laws required someone who threatened the peace to post a bond, essentially a cash deposit, that they would forfeit if they broke the peace. While these laws didn't confiscate guns, they did restrict the free exercise of the right based on a person's dangerous conduct. Going armed laws allowed the government to punish people who carried weapons in a way that terrified the public. Roberts argued that these old laws and the modern 922G8 statute shared a common justification. When an individual poses a clear, adjudicated physical threat to another person, the government has the traditional authority to temporarily disarm them. The principle was the same, even if the mechanics were different. By validating this principle over precision approach, Roberts saved the law, but he also handed lower courts a new weapon to uphold other gun control measures. The only person in the room who refused to sign this peace treaty was Justice Clarence Thomas. His lone dissent is a document that will be studied by legal scholars and gun rights absolutists for decades. Thomas, the architect of the Bruin Revolution, looked at Roberts' opinion and saw a betrayal of the text. Thomas argued that surety laws were fundamentally different from a total ban. A surety law was a fine. It was a tax on bad behavior. It didn't involve police kicking down your door and taking your property. To Thomas, the government had failed the test he created. He warned that by loosening the definitions of history, the court was allowing judges to smuggle their own policy preferences back into the Second Amendment. If dangerousness is the new standard, Thomas asked, who gets to define dangerous? Today it is Zaki Rahimi, a man who shoots at drivers. Tomorrow, is it a man who posts angry memes on the internet? Is it someone who refuses to take medication? Thomas's dissent was a warning flare. Once you decouple the law from the strict text of history, you are on a slippery slope toward interest balancing, where rights are weighed against the government's desire for order. The implications of this 8-1 split are massive, and most people are missing the forest for the trees. The immediate impact is obvious. The federal ban on domestic abusers possessing firearms is secure. The 500% increase in homicide risk when a gun is present in a domestic abuse situation was a statistic that clearly weighed on the justices, even if they didn't explicitly cite it as the legal reason. But the secondary shockwaves are where the real action is. This ruling quietly breathed new life into red flag laws, or extreme risk protection orders, in 21 states. These laws allow police or family members to petition a court to temporarily disarm someone deemed a danger to themselves or others. Before Rahimi, red flag laws were on shaky ground because there were no red flag laws in 1791. But under Roberts' new dangerousness principle, these laws now have a much stronger constitutional footing. If the government can disarm Rahimi because a civil court found him dangerous, they can likely disarm a suicidal teenager or a schizophrenic man making threats, provided there is due process. However, the court left a massive question unanswered, a question that affects over 26 million Americans: the rights of nonviolent felons. Under current federal law, if you have a felony conviction, any felony, you are banned from owning a gun for life. It doesn't matter if your crime was tax evasion, mail fraud, or selling marijuana in 1995. You are in the same category as Zaki Rahimi. Before this ruling, courts were starting to strike down these lifetime bans for non-violent offenders, arguing that a guy who lied on a food stamp application is not historically dangerous. But Rahimi complicates this. The court emphasized that the legislature has the power to disarm those who aren't responsible or law-abiding. Does a tax cheat count as dangerous? Roberts didn't say. But by expanding the government's ability to use principles rather than strict history, the court may have just made it harder for nonviolent felons to get their rights back. The Range and Daniels cases, which deal with exactly this issue, were vacated and sent back down to the lower courts to be relitigated under the Rahimi standard. This means the fight is not over, it has just been reset. We also have to look at the political chessboard. The 8-1 vote included every liberal justice, Sotomayor, Kagan, and Jackson. Why would the most anti-gun justices sign on to an opinion written by a conservative? Because they saw Rahimi as a lifeboat. They hate the Bruin test. They believe it is unworkable and dangerous. But they realized that Roberts' opinion in Rahimi watered down Bruin. It made the test more flexible. By joining the majority, they solidified a precedent that allows for more modern gun regulations. Justice Jackson wrote a concurrence practically begging the court to give legislators more clarity, pointing out the chaos that Bruin had unleashed. Justice Sotomayor wrote separately to say that while she still thinks Bruin was wrong, she is happy that Rahimi at least allows for common-sense disarmament of violent people. It was a strategic alliance. The liberals accepted a conservative rationale to save a gun control law, while the conservatives accepted a looser interpretation of history to avoid looking like they were arming sociopaths. Let's talk about the gun side of Gun and Gavel for a moment. What does this mean for your collection? What does this mean for the ammo you have stacked in your safe? It means that the era of the absolutist Second Amendment challenge might be drawing to a close. For 2 years after Bruin, we saw a flurry of lawsuits challenging everything: machine gun bans, silencer restrictions, age limits, location bans. Lawyers were throwing everything at the wall, hoping the history and tradition test would stick. Rahimi is the Supreme Court pumping the brakes. They are saying, yes, you have a right to carry, but that right is not unlimited, and we are not going to let you use the Constitution as a shield for clearly dangerous behavior. This brings us to the concept of the virtuous citizen. In the founding era, the right to bear arms was often tied to the concept of civic virtue. If you were a drunkard, a rebel, or a threat to the community, you lost your rights. Rahimi essentially modernizes this concept. The court is establishing a binary. There are the people who are protected by the Second Amendment, and then there are those who have forfeited that right. The battleground for the next decade will be defining exactly where that line is drawn. Is a misdemeanor assault enough to forfeit your rights? What about a decade-old DUI? What about admitted drug use? A question that is currently burning hot in the case of United States versus Hunter Biden. The Rahimi decision provides the government with a roadmap to argue that anyone who violates the social contract through dangerous behavior can be stripped of their Second Amendment protections. Consider the practical application for a moment. You are a gun owner. You get into a heated argument with a neighbor. The police are called. No punches are thrown, but the neighbor claims they felt threatened. They file for an emergency protective order. Under the Rahimi precedent, a judge, preponderance of evidence, civil standard, no jury, can order you to surrender your firearms. If you refuse, you are now a federal felon. The Rahimi decision affirms that this process is constitutional because it aligns with the principle of disarming threats. While no one wants Zaki Rahimi to have a gun, the mechanism used to disarm him is a broad net that can catch people who are far less malicious. The due process protections in these civil hearings are often much lower than in criminal trials. You don't always get a court-appointed lawyer. The burden of proof is lower. And yet, the consequence is the stripping of a fundamental constitutional right. This is the danger zone that Justice Thomas was alluding to. When you allow civil orders to trump constitutional rights based on a judge's assessment of danger, you are placing a massive amount of trust in the judiciary to get it right every single time. There is also a massive logistical element here. regarding the enforcement of 922G8. When Rahimi was arrested, the police found the protective order on his table. He knew he was violating it. But in the real world, the background check system, NICS, is only as good as the records fed into it. One of the reasons the Fifth Circuit decision was so dangerous was that it paralyzed the reporting system. If the law was unconstitutional, states stopped rushing to upload protective order data. Now that the law is upheld, we are going to see a renewed push for federal and state databases to talk to each other. We are going to see a push for relinquishment protocols. It's one thing to pass a law saying an abuser can't have a gun. It's another thing to actually go to their house and take it. The Rahimi decision empowers law enforcement to be more aggressive in these seizure operations. For the gun community, this means that the come-and-take-it rhetoric is going to collide with the law and order reality of police enforcing court orders. This decision also creates a strange paradox in the current legal landscape. Right now, because of Rahimi, a person with a civil restraining order against them is definitively banned from owning guns. But a person who has actually served their time for a non-violent felony, like mail fraud, might still have a chance to win their rights back in court because their crime wasn't dangerous. We are entering a weird twilight zone where a civil order might be more damaging to your gun rights than a criminal conviction, depending on the nature of the crime. This inconsistency is going to fuel litigation for years. The Supreme Court didn't finish the puzzle. They just put the corner pieces in place. So, where do we go from here? The Rahimi decision is a signal fire. It tells us that this Supreme Court is conservative, yes, but it is not anarchist. They are institutionalists. They want to preserve the Second Amendment, but they also want to preserve the government's ability to maintain order. They are rejecting the most extreme libertarian arguments that would allow violent criminals to stay armed simply because the founders didn't have a specific statute for them. But in doing so, they have handed a loaded weapon to lower court judges who might be hostile to gun owners. A judge in a deep blue state can now look at Rahimi, find a vague historical principle of public safety, and use it to uphold a ban on semi-automatic rifles or standard capacity magazines, arguing that these weapons are dangerous and therefore restrictable. The principal argument cuts both ways. For the gun and gavel community, this is a call to vigilance. You cannot simply rely on the phrase "shall not be infringed" to protect you in a courtroom. The legal standard is shifting toward a nuanced historical analysis of dangerousness and tradition. If you are involved in a legal dispute, understanding how Rahimi applies to your conduct is critical. It reinforces the absolute necessity of staying on the right side of the law, not just criminal law, but civil law. Avoid the arguments, avoid the confrontations, and avoid the situations that lead to protective orders. Because once that gavel drops in a civil hearing, your Second Amendment rights can now be severed with the full blessing of the Supreme Court. Ultimately, United States v. Rahimi is a case about the tension between liberty and security. Zaki Rahimi was a villain who forced the court to look in the mirror. To save his rights would have been to endanger the public. To strip his rights required expanding the government's power. The court chose the latter. They chose to prioritize the safety of the specific victim over the theoretical purity of the legal test. Whether that was the right call will be debated in law schools forever, but the reality is here. The door is open for the government to disarm those it deems dangerous, provided it can point to a historical principle. This is the new reality. The history books are open, but the judges are now allowed to read between the lines. As we watch the next wave of cases hit the docket, cases about assault weapons, carry permits, and commercial sales, we will see Rahimi cited over and over again. It is the new playbook. If you want to stay ahead of the curve, if you want to understand the forces that are shaping your ability to protect your family, you need to keep your eyes on this channel. We are not done. The implications of this ruling are just starting to ripple outward. Do you think the Supreme Court made the right call? Did they save lives? Or did they crack the foundation of the Second Amendment? Was Justice Thomas right to stand alone? I want to see your arguments in the comments below. Don't just give me a yes or no. Give me the gun and gavel analysis. Tell me where the line should be drawn between a free citizen and a dangerous subject. And if you learned something from this deep dive, if you appreciate the detail we put into this, hit that like button and subscribe. It helps us bypass the algorithm and get this information to the people who need it most. Until next time, stay safe, stay legal, and keep your powder dry.